Joining us now, thanks, Nancy, with more on the Peterson case is legal analyst Terry Sullivan. You're a little surprised by this decision to keep Peterson behind bars.
Well, I'm surprised only to the extent that the law, as I've stated before, says that generally a defendant will enjoy, I'm quoting from a Supreme Court case, an appellate court case, a defendant will enjoy complete freedom. In other words, not even by bond when the state decides to appeal a pretrial order. So I'm surprised from that extent. But, Steve, I think I'm right on this. I have nothing really to back it up but my own gut feeling. And that is that this judge, don't forget, under Drew's law, this is this is the first time this has ever been done. Don't forget, as Nancy said, that he had a pretrial hearing that lasted for several months, I think. And in that pretrial hearing, he had to make a finding, not beyond a reasonable doubt, but by a lesser standard, that in fact Drew Peterson had killed his third wife. Maybe his fourth. We don't know because that hasn't been released. And so I believe that when he went back and took this under consideration today, he said, okay, I've got the law that says that he should be released and that when the state appeals, he should be released. But at the same time, I'm the one, that is the judge, who made a finding that he's guilty of murder. Now, how can I, in good conscience, release this person into the general public? And that if somebody's going to do it, it better be the appellate court. And I actually think that when the truth comes out, I would pretty much bet on that.
Yet this is the same judge that is not allowing some of this hearsay evidence into it. Now the prosecution is appealing that. Peterson's attorney saying clearly they don't have a case beyond the hearsay if they're appealing this ruling. You think that's true? Is their case not?
Well, there is case law that says if the state isn't satisfied with what the trial court does before hearing and they want to appeal, that in fact there must be something wrong with their case. I'm not saying that their case is completely weak, and as a former prosecutor, I think I would have done the same thing to put the whole case together. But at the same time, the courts of appeal have said that it's a rare exception once the state makes an appeal on a motion to keep somebody in custody. So this is a rare exception. And now we have to find out whether this is going to go up to the Court of Appeals in Ottawa, and that may be as early as this afternoon. And I just a couple of minutes ago talked to the very nice clerk of the appellate court out there.
They're all nice to you, Terry.
She was very nice. Her name is Barb, by the way. And she said that they haven't received anything as of yet, and they'll deal with it as they get it this afternoon. So I think the ball now is in Brodsky's courtroom as to what they're going to do.
A little off topic, but did we understand that this jury is going to be impaneled for 6 to 9 months?
Apparently so. Apparently this judge
Can they get on with their lives during that time? Or?
They can. And that may be why the judge, hasn't made this his ruling public yet. But it's going to have to be made public at the appeal somewhere. And these jurors are obviously going to find out that this judge has had to have made a finding on his own, certainly not beyond a reasonable doubt, but nonetheless has made a finding. And the judge, I think quite rightly, was trying to keep prospective jurors from finding out that he had in fact made a finding of guilt, and so that they wouldn't know that and think, well, if the judge made a finding, then we have to make a finding. In other words, not to taint the jury, he did the proper thing. But this has never been done before, and in my humble opinion, I think that his ruling is pretty much going to have to come out in public during the appellate process.
Given the precedent and given the law, do you think that if Drew Peterson appeals this part of it, him being allowed to be free during the wait time of the appeal on the hearsay evidence, do you think that he'll win on that one?
I think under the law he should win, but then again, this is a first-time call, and we don't know because the judge has suppressed, for us anyway, even what his ruling was based on. In other words, he found compelling reasons, but he didn't put on the record or make public what his compelling reasons are. I gave you what I think, just from my pea brain, what I think his compelling reasons are, and I think he had a very good reason to say, I understand what the law says, but how am I supposed to release in good conscience a murderer out into the public who I have found to be a murderer? And I think that's probably what the Court of Appeals now is going to have to deal with.
Well, thank you for breaking down so many complex legal issues.
Well, I hope it was halfway clear.
In a very concise way.
It was very good.
Always a pleasure, Terry.
Thanks, kids.